So today I just want to share with you a few myths and misconceptions that float around a lot in the legal industry and that we face a lot also just in day to day. So just a little bit about me first. My practice areas are all aspects of business and commercial law, and that's actually quite a broad area, which is why I practice limited family law only when there's company structures and trusts and that sort of thing, and a little bit in employment law, but I don't really do any other areas that are out there just because of the size of commercial law, and you got to hone in on one area. So the actual aspects of business and commercial law include the buying and selling of businesses and franchises is probably my favorite thing to do, and the retail and commercial leasing, but just generally reviewing and drafting documents and just making sure that everyone's got their ducks in a row. Just a general little disclaimer, this is just a general sort of commentary on everything that we come across. Any good lawyer will answer you with "it depends" whenever you ask them a question on the spot, so just keep in mind that every matter is by the facts, and what I'm saying now can't really be applied just across the board. It's just a case-by-case basis. So myth number one is "I will see you in court." So a lot of people, as soon as they get into a dispute or someone's wronged them, they automatically jump to, I want my day in court to prove this person wrong, and don't really understand how much it actually costs to go to court. So for some perspective, a recent criminal law matter that has gone through to the High Court, I won't name names, but some people have been saying, oh, this person got special treatment because they've had access to the High Court and any other person wouldn't have been able to do that. The supporters of this particular person were saying, no, this is a free service. Everyone has availability to the High Court. That's what it's there for. That's what our whole justice system is. In reality, that's sometimes true, but also in reality, it costs about $500,000 on average to get to the High Court. So while it technically is available to everyone, to actually get there and have the resources, unless you're using a pro bono lawyer who probably won't get in that deep for a high court matter unless it's going to boost their career for high profile. Access to those higher courts is in a way sort of reserved for the privileged. Typically, if a debt or a loss is less than $10,000 to $15,000, there's not a whole lot of cost benefit in taking a matter to court. Even the lower courts, you're going to spend a lot of money, and at the lower court level also you get less of your costs back, especially if you're using a lawyer that doesn't use scale costs, which there aren't many that do. It also takes weeks and possibly months even just to get to that first initial filing of your application. So you have to meet all of your obligations, pre-litigation obligations, before you even get there. And the larger matters can take up to average 1 to 3 years to get to a final hearing if you actually want to get there. So you can take that more aggressive approach, and a lot of lawyers will do that, and it can actually scare people into paying you very quickly. But the more respected lawyers and the more successful and much happier clients are the ones that will not fight tooth and nail for every single dollar. They won't dig their heels in. They'll take a commercial approach to a matter and they will try and negotiate a settlement early on. It's not just the monetary cost, but also the time costs. And we have a few clients that they've gone through one major court battle and that's enough for them. Most people will go through only one in their life, and that's more than enough for them. Myth number two is that possession is 9/10 of the law. This one is thrown around a lot. It's one of my favorite things to hear from people, and it's also quoted on a lot of TV shows and movies. So in reality, paper trails and security interests are actually 9/10 of the law. So you may take possession of goods or a car or a house, but if there's a mortgage, a caveat or a PPSR registration over those goods, in reality, you may hold them, but you haven't got that priority right to those goods. So mortgages and caveats are extremely powerful because those assets cannot be transferred without your involvement. PPSRs are also very powerful, but these are more relevant when you're looking at someone who's not going to pay their debt or they're going to go into liquidation or bankruptcy, because these registrations will stop the liquidator from taking those goods out from under you and selling them off without your involvement. So having some kind of registered interest over the goods means that you can get your money or you can hold the goods until you've been paid out. Otherwise, you just line up like the rest of the creditors and anyone who's been involved with someone who's gone under knows that there's very rarely anything left at the end of the day after everyone takes their fees for the people who are actually owed the money. This is also on a personal note for everyone. If you're buying a car or a motorbike or like a tangible good, do a PPSR search. They only cost $2. Just jump onto the ppsr.gov site, not the .com site. And you can just put in the number, the engine number, and it comes up. It'll tell you if it's ever been written off. It'll tell you if it's been stolen, and it also will tell you if there's a registration on it. That's important because we had a matter a while ago now, but it was when the PPSR was quite new, and someone had bought a truck from a vendor. The vendor had finance over the truck, so they'd secured the truck with this finance company. They didn't pay out that finance when they sold the truck. Our client didn't do a search or anything, and they came to us after the fact. And of course, the finance company said, well, you've defaulted on your loan, so we're repossessing the truck. And they had every right to, so they took that from our client. He then had no truck and no money, and he had to pursue the person that he bought that truck from. So it was a simple $2 search could have avoided that and make sure that he was actually paying out his finance before any of the money got transferred through to him. Myth number 3 is I didn't sign anything. So execution of terms and conditions and execution of a contract is only one of many indicators that show that parties have reached an agreement and a binding contract. Sometimes it's just the conduct that does this. So this is a big one, especially for terms and conditions on websites, and also just general terms that people don't usually have to sign them. Acceptance of goods when they're delivered after you've ordered on a website, that will typically be acceptance of those terms and conditions. Also, if those terms and conditions are on the back of an invoice, which is provided with the goods when they're delivered, if they have the opportunity to read them and accept those goods, that's it. We had a case where it was a mechanic, and we had to go after him for payment for our client. He accepted an engine, and despite the fact that he had taken the engine, installed it in someone's car and taken money for it, he said, no, I'm not actually paying for this because I didn't sign any terms and conditions. And this was actually the attitude of someone who thought, no, I didn't sign anything, regardless of the fact that he'd ordered numerous times in the past and taken the goods. It was just, this was the whole, there's no binding agreement because I haven't signed any contracts. It's just not the way that it works. Of course, binding contracts and signed, executed documents are better. And of course, they're much easier in court to show without, all of the surrounding facts. But, at the end of the day, if you've taken some goods and the terms and conditions on the website, then it's part performance by the other side, and you'll be liable for that cost as well. Myth number 4 is one of my favorites, and the quote, it's the principle from a client. Depending on how much that client understands the legal system and how much it costs, this can either be a favorite or a least favorite thing to hear as a lawyer. It can be a lot of fun when someone's been rubbed the wrong way and they have knowledge of what it takes to actually pursue it. They say, no, I want to go after them, and they've got the money. It can be very good. But managing the expectations of a client who thinks it's the principle, I'm going to get them, and they've done this and you need to nail them, it can be difficult because it can be quite disheartening for a client when reality sets in that it's just often the law doesn't back them when they've just been wronged. So you may know 100% that someone's done the wrong thing, but it's also what you can show in court. This is why executed documents are good. But unless you've got more than a he said, she said, it's quite difficult. And there's a lot of times when we're in litigation, especially in family law matters, when someone will say, oh, they've done this, I want the court to be aware of it. And it may seem relevant, and it may actually be relevant, but unless you've got some proof of that, it's really irrelevant. And the court really doesn't want to hear about the bickering ex-wives and ex-husbands and all that sort of thing. And so it's also relevant for if someone gets fired up and they say, look, they've owed me all this money, but they've also caused me all this stress. And this is where the, I want damages for pain and suffering comes in. So depending on which side of the law you're on, fortunately or unfortunately, we don't live in the US, and we don't really have the opportunity to make frivolous claims if you slip over in a supermarket, or, you know, deliberately or not deliberately, or, you know, someone's caused pain and suffering. So usually, even in negligence cases, your loss is generally limited to medical bills and a demonstrable loss of income. There's no going after someone for $2 million because, you know, they've given you a bit of anxiety. There are some cases where there's a stressful situation that typically it'll come out in employment, where a employee has been bullied relentlessly for a long period of time, or there's particular conduct that's really damaging to someone. Maybe in those circumstances, it's not unheard of for people to be awarded damages, but as always, it depends on the case, and typically it's not something that's available just day to day. Myth number 5 is I said she or he cheated, so I am taking the house. So this is another one that comes into conduct and pain and suffering and that sort of thing. So we have no fault divorce here in Australia, and a cheating spouse or someone who's not committed to a relationship in another way, it's completely irrelevant to how that property will be split. So people think, oh, I'm going to get them back, I'm going to take everything. But the family court has very wide powers to look into every single aspect of a relationship, and it can be quite daunting for some people that it can be quite nosy. But there's a lot of things that are taken into account, and there's the contributions at the start of the relationship and throughout the relationship, future needs of both parties, including whether one has the kids full time, physical and mental health, and this will really be the only time where conduct comes into play. And if there's been abuse and someone has severe mental health issues because of that abuse, and that will be taken into account, but otherwise not really. And the ability to make an income going forward, that's a big one as well. And that comes into contributions within the relationship. So some people think that this is just financial contributions. So someone's been the breadwinner and, you know, they've paid the mortgage through the entire marriage, could be 20 years, and they also bought the house at the start, and they say, well, I'm taking all of this back. They've done nothing to contribute to this. But the fact that the other spouse has stayed at home and looked after the children is actually taken into account, and it's usually taken as an equal contribution. The reason for this is that someone staying home and looking after 2, 3, 4 children allows that other spouse to go to work for their 9-to-5 job, or however long that their hours are, and actually build their career and do that without having to worry about looking after the children and looking after the house and doing all of those responsibilities. And on the flip side, you know, at the end of a 10, 15-year relationship, the spouse who stayed at home, they've sacrificed their career and they've sacrificed, you know, their superannuation and everything to stay at home and look after children and look after the house and look after the spouse. And the issue with this is, you know, they're starting back at the bottom rung of their workforce when they enter back into it. They're not 10, 15 years senior with those extra zeros on their paycheck. So their ability going forward, and also they'd be usually mature age going back into the workforce, which often is a disadvantage as well, starting with a new career or going back into a career. So those things are really taken into account. And the fact that the other spouse, you know, they've got this large income ongoing, so there's going to be much more of a property split in favour of the stay-at-home spouse to account for that differential.
1 minute, Amanda.
That's okay. I'm done.